Assalamu alaikum. I'm Dr. Mohammed Alsayid. I'm an internal medicine hospitalist, one of the SAMS education committee members. I would like to thank all of you for attending this webinar. And we have today a presentation and a workshop for visas and immigration. Um, Um, so we have today Mr. Charles Wintersteen, and uh, he has been in practice since 1991. He concentrated his practice in immigration and nationality law. Mr. Wintersteen is a graduate of DePaul University College of Law and holds MA and BA degrees from the University of Colorado and the University of Oregon. Mr. Wintersteen is admitted to practice before the Illinois Supreme Court, the U.S. District Court for the Northern District of Illinois, and the U.S. Court of Appeals for the 7th and 11th Circuits. Mr. Wintersteen is a member of the American Immigration Lawyers Association, and he is an active as a board member, volunteer, trainer, and pro bono advocate for several community and immigrant rights organizations in Chicago. Um, I would like to thank Mr. Wintersteen for joining us today, and I would like to invite him to start his presentation, and I would like from all attendees to write all your questions through the question field, and we're going to allow 45 minutes to Mr. Wintersteen to give his speech, and then we're going to allow attendees for questions. I will be reading all the questions, and um, thank you very much, Mr. Wintersteen, for coming today, and you can go ahead.
Okay. Can you hear me okay?
Yes, I can hear you very well.
All right. Well, thank you for that introduction, and thank you for the opportunity to speak. Just to tell you a little bit more about my practice briefly. For my entire career, I've really done nothing but immigration law. But for the past 7 or 8 years, my practice has focused primarily on healthcare, and more it's been focused on physicians, representing employers who hire physicians from outside the U.S. and also representing individual physicians. I'm also, in addition to those other memberships that were listed there, I'm a member of an organization of immigration lawyers called the International Medical Graduates Task Force. And it's a somewhat informal organization. It's immigration lawyers from all over the country who deal with immigration issues for physicians. We have a listserv, so we're always asking each other questions through that listserv, and we have a conference call every 2 weeks. And we're also trying to do some advocacy, trying to talk to congressional representatives about immigration reform, because there's the possibility that sometime in the next year or 2 years there may be some major immigration legislation. And what we've been trying to do is make sure that legislators focus on the important issue of physician immigration, because with the Affordable Care Act, it has become, it was clear even before the Affordable Care Act that the U.S. had a serious shortage of physicians. People talk a lot about the shortage of primary care physicians, but the shortage really extends far beyond that. There's shortages in a lot of specialty areas of practice as well. So we want to make sure that Congress focuses on this issue, makes some changes to the H-1B program, to the J-1 program, to the programs for people to get permanent residence and green cards, so that the U.S. is able to, that employers are able to bring physicians in. Anyone who practices in this area has had the experience, and I've had this experience several times in the last year, where you have a physician sitting in front of you, has completed a residency, perhaps fellowship, has a Illinois license, a permanent license to practice medicine in Illinois, has an employer who wants to hire that person, but there's just no way that it can be done with the restrictions of the U.S. immigration system. That's what we're hoping to correct, and we're hoping Congress will pay enough attention to this that they will make the necessary changes. So anyway, that group is probably, of all the groups that I belong to, that's probably the one that's most important to my practice, that I rely on mostly. And it's the opportunity, it gives me the opportunity to ask questions with colleagues all over the country who are having similar problems, dealing with the immigration system on behalf of physicians and healthcare providers who employ physicians. I want to talk today about the two general visa programs that people use to do residencies, to do graduate medical education in the United States. It's the H-1B program and the J-1 program. And as you listen to someone describe these programs and the peculiarities of the programs and the procedures and the requirements, it sounds chaotic. It doesn't make any sense. It sounds like a system of rules that was just sort of thrown out there. But what you have to understand is that each of these programs has it came from a different place, and it wasn't really designed so much as it just sort of evolved. And really, it's a very rule-bound program, and the only way you can operate within it successfully is to understand the rules, all the particular rules, and try to look ahead in your career and in this immigration process so that you can anticipate things and be in a position to move ahead with your career goals. I'm going to talk about the advantages and the disadvantages of each of those two programs, J1 and H1B. I'm going to talk about what H1B status and J1 status means for your long-term plans of getting permanent resident status, obtaining a green card, and having a career in the U.S., a long-term career as a physician in the U.S. I'm going to talk also about a little bit about the process of becoming a permanent resident. Right now, I think all of you are focused on one, matching to a residency program, and two, getting some kind of immigration status that will allow you to participate in that residency program. But it's really not too early to start thinking about permanent residence and what the different paths are to become a permanent resident. And just to clarify a little bit about terminology, people talk about permanent resident status, about green cards, getting a green card. Permanent resident status is the status you want. The green card is the card that that you use to prove that you are a permanent resident. And lastly, I'm going to talk a little bit about the distinct situation of people who are citizens of Syria, because because Syria is undergoing so much severe turmoil right now, and there's so much political violence. I mean, in general, it is a terrible, terrible situation, but it actually creates some opportunities for people dealing with the immigration system here. Getting permanent residence status, dealing with certain J1 issues. Okay, well, with that introduction, I'm going to talk first about J1s. And J1 is the J1 program, or J1 visas, used to be the only way that physicians who are not U.S. citizens or permanent residents could come to the U.S. and do residencies, do graduate medical education. So it's sort of the default system. And for a while it was being used less and less, and for the last 8 or 9 years it's kind of going back to what it was before. That, in other words, that it's the rule, not the exception. Of all the the international medical graduates who are in the U.S. receiving graduate medical education. Right now, the great majority of them are in J1 status. The J1 program, it's important to understand what it is and where it came from. And there are a lot of people who are in J1 status in the U.S. Who are not physicians, who are not in residencies or fellowships. They're doing a lot of different things. But they're all, to some extent, they're what the government has designated as exchange visitors. They're here for some temporary purpose related to exchange, and the idea is that people will come here in J1 status, doing different kinds of activities, working temporary jobs. They're here as students sometimes, receiving different kinds of training. But the idea is exchange, that these are people who are coming to the U.S. to kind of teach the U.S. something about the countries that they come from, and also the idea is that people are here to have some kind of experience that they're going to take home with them. And the J1 program, one of the things that's distinctive about it is that the J1 program is operated by the U.S. Department of State. And that's the agency of the government that runs is in charge of foreign policy for the United States. It's the same agency that operates all the U.S. embassies and consulates. And that is significant because you have to understand that it was the J1 program was created. What it's about is the U.S.'s relationship with the rest of the world. And many years ago when they first created the J1 program, the whole idea was that people would come here and have some kind of experience, get some training, or be here for a temporary period, and then they would go home and they would tell people in their home country, oh, I had a wonderful experience in the U.S. Everyone there is so nice. It's just a wonderful country. So the goal was to promote the U.S. to the rest of the world. And one of the ideas was that people would come to the U.S. to be trained in different fields, and then they would take that training home with them and use it in the home country. So it was sort of a way for the U.S. to provide assistance to the rest of the world, bring people here, train them, and then they would go home and take that training home with them. And that fact is the origin of the big problem with J1s, the 2-year home country residence requirement. If you're going to have people come to the U.S. and be trained and then take that training home and have it have some kind of impact in the home country, then people have to go home. You have to have some kind of system to make sure that they'll go home. And that's where the J1 2-year home country residence requirement comes from. So that if you come here to the U.S. and you receive some training, the 2-year home country residence requirement is the way for the U.S. government, the Department of State, to make sure that the program is effective. In other words, that you take this training, go home, and don't stay here. Well, in the late 1970s, they really expanded the J1 program, and that's when they began to put physicians into the J1 program. But the idea, and this comes from the J1 program, the broader J1 program, is that people will come here, receive training, and then go home. Now, in the late 1970s, the U.S. medical establishment believed that there was going to be a surplus of physicians coming in 10 years, 20 years. And they were very concerned to make sure that people who came here and did training didn't stay. They needed those people to staff teaching hospitals, and there just were not enough U.S. graduates. There weren't enough people coming out of U.S. medical schools to fill all the residency slots, so they needed foreign medical graduates to come here and participate in these residency programs. But and the truth was that those people, those physicians coming from outside the U.S. were important in terms of making the hospitals operate, making the residency programs operate. But they adopted this fiction that people were coming to the U.S. To receive training, and then they were going to take that training home. Well, that's the fiction. The reality is that it just doesn't make sense for a physician to come to the U.S. and do residency training unless they're planning on staying here. The training that you receive in a residency program in the U.S. trains you pretty well to practice medicine in the United States. The healthcare systems and the healthcare infrastructure in different countries all over the world, it's different in all those places. And if a person really wanted to practice medicine in, let's say, in Syria, in India, in Pakistan, in South Korea, in Colombia, wherever, the place to get training to do that is in those particular countries, not in the U.S. But that's the reason the 2-year foreign residence requirement sort of hangs over the J1 program, and it's the big problem that you're going to have to solve as you move forward. First step is getting J1 status, matching to a residency program, getting J1 status, and then as soon as you have J1 status, you need to be thinking about how you can get rid of that 2-year foreign residence requirement. But what I was telling you about the origins of the J1 program and the overall nature of the J1 program, that provides some insight or explanation as to why you have to deal with these sort of particular procedural requirements. And that's the reason that there's a requirement that you have a letter of need from the Ministry of Health in your home country. The Ministry of Health in the home country has to buy into this myth that you're coming to the U.S. to get training that you're gonna take back to your home country. And another requirement is when you apply for a J1 visa at a U.S. consulate outside the U.S., one of the requirements is that you have to demonstrate, you have to prove that that you're not intending to live permanently in the United States, that you are intending to come to the U.S., get this training, and then go back. It puts you, the individual applicant for the J1 visa, in sort of an absurd situation, because you have to go in there to the consulate and say something that really is not true, and you know it's not true, and probably the officer that you're dealing with knows that the only reason that people come to the U.S. to do residencies and fellowships in general is because they want to have careers in medicine in the United States. But yet you have to demonstrate and you have to tell them that your intention is to just be in the U.S. temporarily, that you're not interested in staying and becoming a permanent resident. You're not interested in immigrating. But that's sort of my general introduction to the rationale of the J1 program and where it came from. Now, in terms of procedure, the process that you go through to get a J1 visa or to get into J1 status in the United States is that you have to deal with an agency called, you're already familiar with, the ECFMG, the Educational Commission for Foreign Medical Graduates. Everyone who is in J1 status in the U.S. receiving graduate medical education is part of the, in J1 status, is part of the, is sponsored by the ECFMG. The ECFMG, after you match to a particular residency program and the decision has been made that you're going to do the residency in J1, the ECFMG issues you a document called DS 2019. It's a Department of State form, and it's the form that you use to prove that you're eligible for a J1 visa or J1 status. And there's two ways that you can get into J1 status. If you're already in the U.S., when you match and when you receive the DS-2019 form from the ECFMG, you can file an application with the U.S. Citizenship and Immigration Services, USCIS, to have them change your status from whatever it was before. Let's say you were in student status or you were here in visitor status. If you're here in the U.S. and you're in some kind of other non-immigrant status, you can apply to the Immigration Service, the USCIS, to change your status to J1 status. And you would send the USCIS, you send them there's a form, the I-539, application for a change of non-immigrant status, and you send the original DS-2019 form that you received from the ECFMG, and you pay the Immigration Service a fee of $290 and give them a copy of your passport and your I-94 card or the I-94 printout that you got from the government's website, and ask that they change your status. That has certain advantages. The principal advantage it has is that you don't have to leave the country. The problem is that the Immigration Service is very slow in processing those applications. They typically take, I would say, at least 3 months to process them. And if you don't get the DS-2019 form from the immigration or from the ECFMG until let's say a month after you match in mid August, if it takes you mid-April to get the DS-2019 form from the ECFMG, and then you put together your application, you send it off to the Immigration Service, and it takes them 3 months, that puts you into the middle of July or maybe the end of July. And by then, the program that you're going to, they're calling you up. They're saying, is there a problem? We thought you were supposed to be here July 1st. So that's the difficulty with doing a change of status in the U.S. The Immigration Service is slow, and there's a risk that you're going to be starting your program late. The other way to get J1 status is you take that form that I talked about before, the DS-2019 form that you get from the ECFMG, and you leave the U.S. and you go to a U.S. consulate, and you apply there for a J1 visa. Usually, in the great largest percentage of situations, you're going to get the J1 visa quickly in about 2 weeks. Occasionally, people are going to have a problem where for some reason the consulate takes longer to issue the J1 visa, but usually it's done pretty quickly. But the problem is, if you're in the U.S., when you match to the program, it's going to be, frequently people don't want to leave. Because whenever you leave and you're going to have to go to a U.S. consulate and apply for a new visa, there's a certain amount of risk. There's always a risk that the consulate won't issue the visa. It's the quickest way to get J1 status. It's the way to get J1 status so that you're most likely to be able to start the program on time, but it has this risk. In a small percentage of cases, the officer that you're dealing with at the consulate decides that you haven't, for some reason they decide that you haven't proved that you have the intention of going back to Syria, or they think there's some other problem. Sometimes there's confusion. If you have the same name and birthday of somebody that they think lied to them before, that there's some kind of security issue with, that can create delays. But that's the other way that you can obtain J1 status when you match the program. When you let's assume that, let's kind of look ahead here. Assume that there's no problems when you apply for the J1 visa. Get your J1 visa, and you come here. You come here to the U.S. You start the program. Every year that you're in the program, every year of your training, whether it's residency or you stay and do a fellowship, every year the ECFMG will issue you another DS 2019 form. The form that they issue you year to year is just good for 1 year. It says that you are participating in this program for the current year, from July 1st, 2015 to June 30th, 2016. And then the following year, they'll issue you another DS 2019 form that says that you're going to be continuing in the program for another year until June 30th, 2017, and so on. There are well, the question that people ask sometimes is, well, how long can you, for how long will they continue to give you those 1 year DS 2019 certificates? And in general, the limit, ECFMG's limit is 7 years, so that you can do a 3-year residency in internal medicine, for example, and then do 1 year as a chief resident, and then go into a 3-year fellowship program like cardiology or gastroenterology, and you have enough time. As I said, their limit is 7 years, so with a program like that, kind of following those steps, you don't have any problem. If you want an extension of J1 status beyond 7 years, the ECFMG has procedures. They regard that as an exception, and if you can show them some special reason why you should be granted more than 7 years. And people, really the only reason that people ever want more than 7 years is that they've been some kind of change in their program. They do a couple of years in internal medicine or something, and they decide they want to go into some other program that's longer. So in general, their limit is 7 years, but you can ask them to make an exception and grant you J1 status, grant you time in J1 status beyond that limit. But as I said, the overall problem that hangs over J1 status is the 2-year home country residence requirement. When you sign the DS 2019 form that you're issued every year, you are promising the Department of State, the Immigration Service, the ECFMG, that you intend to go home after you complete your training. And the 2-year foreign residence requirement, or home country residence requirement, is strict in that it requires you to, after you've completed your J1 training, not just to be outside the U.S. for 2 years, but to be in your home country, in the country for which the Ministry of Health issued the certificate of need, or the letter of need. So if you're from Syria and you're subject to the 2-year foreign residence requirement, and you go back and you live and practice for 2 years in Lebanon or Turkey or Jordan or somewhere else, you still haven't satisfied the 2-year foreign residence requirement. It has to be 2 years in the country of last permanent residence, the country that issued the letter of need. The other type of visa that people get is H-1B status. And in general, you're not going to have a choice about whether to get H-1B or J-1. A lot of programs these days have a J-1 only rule. In other words, they'll only allow people to do, foreign medical graduates to do residencies in J-1 status, and they will not do the paperwork for H-1Bs. There are still some programs out there that do H-1Bs. 7 or 8 years ago, or a little longer, maybe 10 years ago, there was a trend for a while that there were more and more programs offering H-1B visas. But about 7 or 8 years ago, it began to swing the other way, and I think that trend is continuing. Every year there are more programs that are J1 only, and there are fewer programs that will offer H-1Bs. H-1B is a type of visa that it's for people who are coming to the United States temporarily to work for some employer in a professional position. That's the principal requirement for H-1B status. It has to be you have to be working in a job that requires at least a 4-year degree. For physicians, that's not a problem. I mean, everyone knows that medicine is a professional position, so that's not an issue. But in general, in the U.S. and H-1B status, it's a lot of IT people, engineers, school teachers, lawyers, accountants, people working in a great number of different professions temporarily in H-1B status. The process for obtaining H-1B status is the employer, in this case the hospital or the residency program, needs to file a petition with the Immigration Service requesting that you be granted H-1B status. If you're in the U.S., and the employer agrees to file a petition for H-1B status, they can request that your status be changed from visitor status, if that's B2 visitor status, if that's the status you're in, to H-1B status. And unlike the J1 situation where you're applying for a change of status, employers have the option. Well, with that change of status, people changing to J1 status, the problem is that it can be very slow. For a change of status for an employer program filing a petition for someone to change status to H-1B, they have an option. There's a way that you can deal with that problem of the Immigration Service processing being slow. You can pay the Immigration Service an extra $1,225 for premium processing, and then they will make a decision on the petition within 15 days. So that problem that people have doing a change of status from visitor status to J1 status, the problem with the Immigration Service being slow doesn't really exist in the H-1B context. And this is part of the reason that there are fewer and fewer programs who do H-1B petitions, is that the Immigration Service has a very firm requirement that the employer, in this case the program or the hospital, pay for all the H-1B processing, that they pay for the filing fees to the Immigration Service, and they also pay, if there's an attorney who's preparing the application, the employer has to pay for that. The Immigration Service and the Department of Labor believe that it's a violation of the conditions of H-1B status to have an H-1B employee pay those fees. There was a time, as I said, that the Immigration Service, the law hasn't changed. That requirement has really always been there, but for a number of years, it was generally ignored by a lot of employers and ignored by the Immigration Service. And back 10, 15 years ago, it was very common to have H-1B employees hire an attorney, pay all the fees for H-1B status, but that really doesn't happen anymore because there's always a risk that the Immigration Service will ask about that issue later when a person has been granted H-1B status, and if they find out that the employee has paid the H-1B fees, they can issue what they call a notice of intent to revoke, to take your H-1B status away. You don't want that, employers don't want that, and everyone knows about it now, so everyone is pretty well aware that employers cannot pay H-1B costs. But the additional cost of paying for H-1Bs is one reason that programs a lot of programs have gone to J1 only. For H1B, to get H1B status, there's an additional requirement in terms of the exams, the tests that you have to pass. To qualify, to match, to go into a residency program in general, you have to pass USMLE Step 1 and the 2 parts of Step 2. To be eligible for H1B status, you have to have also have passed USMLE Step 3. So if you match to a program where the employer says, well, yes, we do offer H1B and we'll file an H1B petition for you, but you don't have USMLE 3, it's really not going to do you any good. So that's one thing to keep in mind. The primary advantage to H1B status is that you are not subject to the 2-year foreign residence requirements, so that when you complete your training and an employer wants to hire you for an attending position or for a regular job as a physician, there's no barrier in terms of the 2-year foreign residence requirement. They can just file another H1B petition for you. Or you're also eligible for permanent residence status. The J1 2-year foreign residence requirement makes you ineligible for H1B status and ineligible for permanent residence status until you have either obtained a waiver of the 2-year foreign residence requirement or you've gone home for 2 years and complied with the 2-year foreign residence requirement. It doesn't make you ineligible to come back in some other types of status. You can always come back to the U.S. in visitor status. It doesn't make you ineligible for student status, and it doesn't make you ineligible for O status, which is another type of employment visa. The requirement for O status is that you show that you are a person of extraordinary ability within your profession. But the 2-year foreign residence requirement doesn't. You can still get O1 status even if you're subject to the J1 2-year home country residence requirement. Some other advantages to the H1B program is that in some situations it's easier to moonlight if you're in H1B status. If you're in your second or third year of residency and you find that you have more time than you did before and you want to make some additional money, if another employer files a separate petition for you for you to work 12 hours a week or 3 or 4 shifts per month, you can do that. The other employer has to file an additional H1B petition, but in that situation you can moonlight. For J1s can really only moonlight within the institution where they're doing the residency, and it can be difficult because under the ECFMG's rules, you're only eligible. The only activities you can participate in are ones that are part of the residency program. So if you're going to be doing some work that's really not part of the program, it's really not. In that situation, it would be a violation of your J1 status to provide services, to do work that was not part of the residency program. For H1B status, one of the disadvantages to H1B status is there's a limit of 6 years. So the scenario that I laid out before, 3 years in internal medicine, then 1 year as a chief resident, and then going into a fellowship program that's going to be 3 years, that can be a problem because that all adds up to 7 years and you can only get H1B status for 6 years. And at the end of 6 years, the rule is that the person is supposed to stay to live outside the U.S. for 1 year before you're eligible to extend your H-1B status. There are some situations where you can get around the 6-year limit of H-1B status if you have an approved immigrant petition. And I'll talk a little bit more about that in a couple minutes. Another important difference between J1 status and H-1B status is the situation of the physician's spouse. For people who are here in J1 status who have a spouse and children, the spouse and children can be here in J2 status. And if you are in the U.S. in J2 status, you're eligible to apply for an employment authorization card. So if you have a situation where you have a spouse who is a physician and is also interested in doing a residency, or if you have a spouse who has some other type of training in information technology or engineering or accounting or something and wants to work, the J2 spouse can apply for an employment authorization card. And it's pretty much always granted, and that allows the J2 spouse to work. And for some people, some couples, that can be an important benefit. Right now, for the dependents of H-1Bs are granted H-4 status, but right now there are no provisions for H-4 dependents of H-1Bs to get work authorization. H-4 status right now does not allow a person to work and doesn't allow a person to apply for an employment authorization card. There's a proposal to change that, but it's the proposal, and this will probably happen, is limited because it's only H-4 spouses of H-1Bs who also have an approved immigrant petition. But for two physician families, couples where both spouses are physicians and want to do residencies, sometimes J1 status works because the J2 spouse can get employment authorization, and that's a way to do a residency and fellowship. And then the program really, if a person if the J2 spouse has an employment authorization card that they were issued just by being J2 spouse, the program really doesn't have to do anything. They don't have to file anything with the Immigration Service. You don't need to get anything additional from the ECFMG. The J2 work authorization card allows a person to work anywhere, doing any kind of job, including being a resident. As I said before, in general, people who come to the U.S. in J1 status and do residencies and fellowships come here because they want to have careers in medicine in the United States. So if you're here in J1 status and you're coming to the end of your J1 program, the problem is, how do I stay? How do I get a waiver of the 2-year foreign residence requirement? And there are several different programs under which people obtain waivers. There has always been a rule that if another government agency has a particular interest in some individual staying in the U.S., that agency can file paperwork with the Department of State to say, we understand this person is subject to a requirement that they go home, but it's important to us that this person be able to stay here because they're doing things that benefit us and benefit the country. And in the past, some people, these programs still exist. If you had a person who was doing some important medical research and the U.S. Department of Health and Human Services or the Centers for Disease Control or somebody said, this person really needs to stay here because they are they're a crucial participant in this important research. Then the Department of Health and Human Services could ask the Department of State to let the person stay. That was known as an interested government agency request for a waiver of the 2-year foreign residence requirement. In the past, there were programs. For a while, there was a program where the U.S. Department of Housing and Urban Development could request waivers for people who were going to be serving at clinics or hospitals that were providing care to people who lived in public housing projects in cities in the U.S., although that program has ended. There's a program, the Appalachian Regional Commission, which is an agency of the federal government that was created to promote economic development in the Appalachian region of the United States, an area that was generally seen as economically depressed. For someone who was going to be working at a clinic that was within the Appalachian, within the jurisdiction, the area controlled by the Appalachian Regional Commission, the Appalachian Regional Commission can request that the person be granted a waiver of the 2-year home country residence requirement if they've signed a contract to work for 3 years. There's another federal government agency called the Delta Regional Authority, which is supposed to be promoting economic development in the region and the Mississippi River Delta. And this includes a lot of the state of Mississippi and some parts of the states of Kentucky and Tennessee and Southern Illinois and Arkansas and Louisiana. The Delta Regional Authority can request waivers of the 2-year foreign residence requirement, again, for people who have signed 3-year contracts. But the program that's most popular, that most people gravitate to, is called the Conrad 30 program. And in that program, the Department of Public Health in one of the 50 states, it's 50 states in the United States, and each state can request 30 waivers per year. And the difficulty with that program is that there's 50 different states and there's 50 different programs. They all have different rules for how they operate their Conrad 30 waiver programs. There's also a separate waiver program from the Department of Health and Human Services for people who are going to be working at health centers that are funded by the federal government, but that waiver program is only for people who are going to be doing primary care. The Conrad 30 programs can do waiver requests for people who are going to be practicing in a specialty area of practice. In addition to those, and all those programs fall under the general heading of interested government agencies. The Department of State and the Immigration Service can also grant someone a waiver of the 2-year home country residence requirement on the basis of hardship to permanent resident or U.S. citizen family members. So if during the time that a person is here in the U.S. Completing residency and fellowship, that person, that physician either marries a U.S. citizen or has children, and if the children are born in the U.S., the children will be U.S. citizens. If you can demonstrate that those U.S. citizen children or U.S. citizen spouse would suffer extreme hardship if the family had to go back to the home country for 2 years, the Department of State can grant a waiver on that basis. What you need to remember about that is that type of waiver requires a a qualifying U.S. citizen or permanent resident family member. If you just have, if the for example, you have a physician who's from Syria, and that person is married to someone else who's a citizen of Syria and has no status in the U.S. There's no way you can apply for a hardship waiver. You need to have either U.S. citizen or permanent resident spouse or children to apply for hardship waiver, because the hardship that matters is the hardship that the U.S. citizen family members would suffer if the family had to return to the home country. There is, you can also be granted a waiver of the two-year home country residence requirement if you can show that you individually have some reason to fear persecution in the home country. And for a persecution waiver, you don't need to have a qualifying U.S. citizen or permanent resident family member. I'd like to talk a little bit now about permanent resident status and the way people get permanent resident status. In general, in the U.S., for people who are becoming permanent residents or getting green cards based on their employment, most people get permanent resident status based on a job offer from an employer in the U.S. And the employer has to first demonstrate to the Department of Labor that there's no qualified U.S. workers available for the job. And that process is called labor certification. And it's also sometimes called the PERM process. But what's distinctive about the U.S. system in general is that it's a job offer from a particular employer that moves the process forward. The employer has to go to the Department of Labor, go through this sort of elaborate recruiting process, publish ads, put some notices on various websites, put a physical posting up at the job site, and demonstrate that there's no qualified U.S. workers available. Then once the employer has proved that to the satisfaction of the Department of Labor, the next step is the employer files an immigrant petition with the Immigration Service, and the last step is the individual applies for an application for adjustment of status. It's difficult to go through that process while you are still receiving training, because the job that you have as a resident or as a fellow cannot be the basis of labor certification, because it's by definition temporary. So the program that you're in cannot file, the program that you're in as a resident or fellow can't file an application for labor certification and an immigrant petition for you, because the job that you have, the job that they're offering you, is temporary. The only way that the employer, the hospital or the healthcare system, could offer you a permanent position that could be the basis for you getting a green card eventually, is if they were offering you a job not as a resident or fellow, but offering you a permanent job. And the difficulty is that when they file the application for labor certification, you have to have all the necessary credentials for the job. And if the job is if the requirements for the job are a medical degree and an Illinois license, or Washington State license, or California license, whatever, if the requirements are a medical degree, permanent license to practice medicine, and either board certification or eligibility for board certification in internal medicine, you won't have those. You won't have that board certification or board eligibility if you haven't completed the residency process yet. So that's a problem that can be solved certain ways. It can be it can be solved by sort of adjusting the requirements for the job. And frequently employers file applications for labor certification saying that the job requires a medical degree and a permanent license to practice medicine and at least 2 years of training in internal medicine. And that way they can file it for a person who is in the 3rd year of a 3-year internal medicine residency program. But there's another program that I've used in a number of, for a lot of people here in the Chicago area. In the city of Chicago, and I think this is true in a lot of cities in the United States, a lot of the teaching hospitals are located in areas, within the city that are low income, that have been designated as underserved and not having sufficient medical resources, medical healthcare professionals to provide care to the population that's there. And there is a program, in addition to the sort of the default path, the usual path of labor certification, becoming a permanent resident based on an employer's job offer. There's a program called the National Interest Waiver Program. And what is being waived in that program is the requirement of a job offer and the requirement of labor certification. And the idea of that program is that if a physician has worked 5 years in a shortage area or can demonstrate that they have a contractual commitment to work for at least 5 years in an area that has been designated as underserved, that can be the basis for the physician filing a self-petition. In other words, you don't need an employer to file it for you. You can file it for yourself to be classified as eligible to immigrate. This program is for the people who qualify, it can be very helpful. One of the difficulties is that J1 time spent in J1 status does not count toward that 5 years that you need in order to qualify for the National Interest Waiver Immigrant Petition. And the reason for that is that in order to get J1 status, you already promised that you would go home for 2 years. So time in J1 status cannot be used to qualify for the National Interest Waiver. But if you're in a program where you are in H-1B status, where the employer has filed an H-1B petition for you and you're in H-1B status, you're working in H-1B status as a resident, then that time, and you are working within an area that has been designated as a health profession shortage area, that's the magic language, that time can count toward the 5-year requirement for a National Interest Waiver petition. And it's not just H-1B status, it's any status, any lawful employment status that's not J1. And I've done National Interest Waiver petitions for people who did residencies in J2 status, or people who had work authorization on some other basis. So if you match to a program where they will do an H-1B petition for you, and the hospital where you're working is in an underserved area, that can put you ahead in in terms of getting a green card, because it'll make you eligible for this National Interest Waiver Program. In general, being in J1 status and being subject to the 2-year foreign residence requirement, it's going to add 3 years to the time it takes for you to become a permanent resident, because all the programs that I talked about before, the state Conrad 30 programs, the Delta Regional Authority, the Appalachian Regional Commission, Health and Human Services, clinical waivers, all those programs require that you work for 3 years in that particular position in H-1B status. And you're not really you haven't completed the waiver process. You don't really have the waiver until you complete 3 years in H-1B status working in this, whatever the particular shortage area is. So that what that means is after you complete your training, instead of being able to become a permanent resident right away, you're going to have this additional period of 3 years where you have to work in a waiver job in order to be eligible for permanent resident status. Now, I also wanted to talk just a little bit about the particular situation of people from Syria right now. Syria has been designated for what they call temporary protected status. And temporary protected status is a program, an immigration service program, where if there's a particular country that has either suffered some kind of natural disaster like a earthquake or a hurricane, or is experiencing high level of civil war, a lot of high level of political violence and civil disturbance, then the Immigration Service can designate that the citizens of that country as eligible for temporary protected status, which means that you have protection. You can stay in the United States under the protection of the United States for whatever period the government, for however long they designate it, and you get employment authorization. And in March 2012, because of the Civil War, Syria was designated for TPS status. And then there was an additional announcement after that in the summer, in June of 2013, where they redesignated it. But the requirement right now is that you have to have been in the U.S. No later than the time of that second designation in June of 2013 and have registered for temporary protected status. Temporary protected status, when the Immigration Service has granted temporary protected status, it usually continues for a long time. And I'll give you an example. There was just an announcement that they redesignated or they extended TPS status for people who are citizens of Honduras. Well, how did Honduras get TPS? Honduras was designated for temporary protected status in I believe it was November or December of 1998, because Honduras was struck by a severe hurricane. Well, since then, they have continued it. They've continued it and continued it. And the announcement just last week was that citizens of Honduras were going to have another 18 months of temporary protected status. There's a similar situation for El Salvador. El Salvador had a severe earthquake in 2001, and citizens of El Salvador were granted TPS in 2001, and since then they have extended it and extended it. And the reason I'm saying that is that I've talked to some people over the last year people from Syria who were granted temporary protected status, and they're a little bit nervous about it because they think that that it could end sometime soon. I don't think it will. In the 1990s, citizens of Liberia had TPS status for over 10 years. As I said, for Honduras and El Salvador, it's gone on for more than 14 years. For Honduras, it's almost 15 years now. I don't anticipate that the temporary protected status for Syria is going to end anytime soon. I think we could expect it to. I mean, it'll end when the violence in Syria ends and Syria becomes a peaceful, prosperous country that's able to reabsorb all the people who are outside Syria. And I just don't think that's going to happen soon. So if you've been granted TPS, I don't think you need to worry about it going away. You're going to have to, the government does this extension of TPS a year and a half at a time. They extend it for a year and for another year and a half, and you have to apply for another employment authorization card that's good for that period. Then you wait for another year, a little bit longer, for them to extend it, and they always do. And then you have to apply for another employment authorization card and re-register. But I think it's going to continue. So if someone had TPS now, that is a way that they could do a residency or fellowship. And it will continue, I think, long enough for someone to do 3 years in internal medicine and another 3 years in a fellowship in something else if they wanted to. And it doesn't make you ineligible for permanent resident status. If an employer files a petition for you, or if you qualify for the national interest waiver petition, you can move from TPS to permanent resident status pretty easily. I wanted to say a couple things about asylum, because I get some questions about asylum. To be eligible for asylum, well, I was talking before about J1 hardship waivers. J1 hardship waivers are granted based on the general conditions: civil unrest, violence, and the fact that the U.S. citizen family members would suffer if the family had to go back there. Asylum is different. It's not. You can't be granted asylum just on the basis of general civil unrest or a lot of political violence. You have to show that there's something about you individually that makes it likely that you would be a target of persecution, that some group is going to be coming after you. So it's a different kind of issue. You have to show that you have to show good reason to fear that some particular group could be the government, or it could be some armed group that the government can't control, has reason to you have reason to fear persecution from that group, reason to fear serious harm from that particular group. So it's an individualized consideration, and really doesn't have that much to do with general conditions of political violence. You have to show that you have an individual reason to fear that some particular group is going to be coming after you. The other thing about asylum that is important to recognize is that there's a time limit on it. There's a requirement that a person file an application for asylum, within 1 year of arriving in the United States. There's a number of exceptions to that, but it's asylum is subject to this 1 year rule, 1 year deadline. And if a person was considering applying for asylum, and if you're granted asylum, the benefits are significant. You're considered to be an asylee, which means you can stay in the United States after you've been granted asylum. You have employment authorization, and at the end of 1 year of being in the U.S. as an asylee, you can apply for permanent residence, for a green card, for adjustment of status. So if you're granted asylum, it leads directly to permanent resident status. But as I said, if you were considering applying for asylum, you should definitely talk about it with an attorney. I think it would be a mistake for someone to try and apply for asylum on their own. It's a tricky process. You want to be represented. You want to be well advised. You're going to have an interview with an asylum officer who will ask you a lot of questions, and you really want to be you want to talk to an attorney who's going to prepare you well for that interview, and you also want to have an attorney there sitting next to you in that interview. So if you're considering applying for asylum, it's sort of it is a way to solve all these problems, but it's not for everybody, and it's intended to be a remedy for exceptional circumstances. So the general idea is that it's a minority of people who will qualify for asylum. So that's pretty much all I have. I've taken more than the time that I said I would take, but I could answer questions if people have questions.
Yeah, thank you very much for a very nice presentation and really very informative. A lot of information that I didn't know actually about before. Thank you so much. I think I have 26 questions here.
Oh my goodness.
So yeah, we have, but we have plenty of time. We have
Okay.
maybe 50 more minutes. So I'm gonna start with the first question. I'm gonna start reading them, and I would like everybody to ask more questions, but just to wait. Maybe your question will be answered, or maybe has been answered through the lecture or through other questions before. So the first question is, how can I change TPS to green card?
Well, to change TPS to a green card, TPS by itself does not qualify you for a green card. In other words, you can, if you can extend your TPS year after year for the next 10 years, and that really doesn't make you eligible for a green card. To qualify for a green card, you need some basis for immigrating, either the National Interest Waiver Program or labor certification, an immigrant petition filed by an employer based on a job offer, or marriage to a U.S. citizen. Those are all ways that a person can immigrate. Each one of those is a basis for a person immigrating. TPS, as I said, you can stay in TPS forever for the next 10 years, and that by itself will not get you a green card, will not get you closer to immigrating. You need a basis for immigrating, one of those other categories.
Next question, if I got J1 or H1 visa, can I go outside the state for medical conferences or family visits?
Well, it depends on how you got J1 status. If you got J1 status at if you were granted a J1 visa, so you have a visa stamp in your passport that allows you, that's a multiple entry passport or multiple entry visa, then you can leave and come back in J1 status. And for H1, but if you came to the U.S. as a visitor, changed your status here from visitor status to J1 status, and then you leave, you can't come back until you have a visa stamp in your passport. So if you were traveling abroad to go to a medical conference, while you were outside the U.S., you would need to go to a U.S. consulate and get a J1 visa stamp in your passport, and that would allow you to re-enter. If you're in H1B status, it depends on, again, the question is whether or not you have a J1 visa in your passport. If you were here in the U.S. in visitor status and you changed to H1B status, the employer filed a petition for you to change to H1B status, and it was granted. That doesn't at that point, you don't have a J1, or you don't have an H1B visa in your passport. You don't have a visa stamp in your passport. And then same situation, while you were abroad, you would have to apply at a U.S. consulate for an H1B visa. I want to say that's a good question because it brings up something that I wanted to talk about before. And I talked for a little bit about non-immigrant intent and how to be eligible for a J1 visa. You have to prove that you don't intend to live permanently in the United States. One of the advantages of H1B status is that that's not a requirement for H1B status. In other words, a person can have the intention of living permanently in the United States, and you're still eligible for an H1B visa. And that is important That's important for the question of where you apply for um, a visa, an H-1B visa or J-1 visa. You just have situations where people were in the U.S. in some kind of visitor status. They match to a program, they get a DS 2019 form from the ECFMG, and then they go up to one of the U.S. consulates in Canada, to Ottawa, Toronto, Montreal, and apply at the consulate there for a J1 visa with the idea that I'm going to apply there for a visa, get the visa, come back, I'll be in J1 status, I can start the program. And this happens to people applying for student visas too at those embassies or those consulates. At the consulate, they tell you, well, J1 status, that requires that you prove non-immigrant intent. That requires that you prove that you have the intention to go to your home country. We, meaning the people at the consulate in Toronto, we have no way to judge whether you intend to return to Syria after you complete your J1 program, because we don't know anything about Syria. We don't know anything about the nature of your ties, whether you have family there or property there. So we can't judge whether or not you have the intention of returning home. The only people who can really do that are people at the U.S. consulate in your home country, so go there. You don't encounter that problem with H-1B status. So if you're a citizen of Syria or Lebanon or Jordan, and you go to the U.S. consulate in Toronto and you say, I've been approved for H-1B status, here's my H-1B approval form, I want to apply for an H-1B visa, they'll go ahead and process it. And as long as there's not any other problem, they'll give you the H-1B visa because you don't have to prove non-immigrant intent. So that's a sort of a long answer to the question. And the question of whether you can get back really depends on whether you have a visa. But if you're granted a change of status here from, say from visitor status to H-1B status, that's not the same as having a visa. You can only get the visa stamp in your passport at a U.S. consulate outside the U.S.
Yeah, I think some people actually they mix the terms between visa and status, and there's a
Mm-hmm.
big difference between visa and the status. I would like you to correct me if I'm wrong, but my understanding is that your status of J1 or H1 means that you have papers that prove that you can work under this status, which is the J1 or H1, but that doesn't mean that you have a visa. The visa is the stamp you have on your passport that allows you to enter the United States. So the visa, it only allows you to enter the United States, but the status, it what allows you to work or study or do whatever you want inside the United States. So someone who changed his status inside the United States will have paperwork that proves and allows him to work in the United States, but he's not going to have a visa stamp on his passport, which means that he's going to have a status, but he's not going to have a visa. So when you say I have a visa, that means that you are able to enter the United States, which means that you have a stamp on your passport.
Right.
Just like my case, like now when I switched from my J1 to I'm doing now a J waiver, so I changed my status from J1 to H1. So now I have H1B status, but I don't have the H1B visa. I have to go outside the United States I have to go to a U.S. embassy, a consulate to get a visa stamp in order to come back and enter the United States.
Right, that's completely correct, and it's a very important point. And frequently, if there's somebody here in the U.S. and I'm filing a petition, an employer's petition to change that person's status to H-1B, they'll ask, well, when's my visa going to be approved? Where's the approval for my visa? How about that petition for me to get my visa? And I say, well, you're going to have H-1B status, but you will not have a visa. A visa is something else. A visa is a stamp in your passport that allows you to be admitted to the United States. So, as I said, you're completely correct, and it's an important point, and it's one that people frequently don't understand.
I have a question here. He says, my question is, if I have a B1, B2 visa, which is valid for multiple entries, and I want to do research in the next year, do I have to change it before going to the United States, or should I not?
So the person asking the question is outside the U.S., um, but has a valid
Valid,
visitor
yeah,
visa.
visitor visa with multiple entries.
hmm Well, it depends on. I mean, if you're going to come here to the U.S. and be paid for doing the research here, you would really need to be you would need some different status other than visitor status. Um, if you were going to come here and um,
Volunteer.
do volunteer, you might be able to do that, but um, it would really depend on where you're going to be doing the research and the nature of it, and there's some risk there because um, I've seen situations where even though somebody wasn't being paid, the Immigration Service still considered it employment. And if the question they ask is this something that the institution would normally pay someone to do? And they can consider it employment. Also, if you're coming here to do research as a volunteer, the Immigration Service, when you're entering, might question whether you're really a visitor, whether you're just going to be here for a brief period of time and then go home. If you tell them that you're going to go somewhere and do research as a volunteer, they might be inclined to think that that you're going to be a volunteer for a while, but your long-term goal is to do something else. And they say, well, if your goal is to engage in professional activities as a medical researcher, you need a type of visa that would allow you to do that, and we don't think a visitor's visa. Visitors visas are just for people who are here for a brief period who tend to go home. If a person, I've had situations where people who are in the U.S. in visitor status came in and would ask, is it okay if I do some volunteer research? And I said, well, just as long as it's very clear that it's volunteer and also temporary, that you not be paid and it be just something that's don't expect to be here long term. And when you're admitted in visitor status, if you're admitted as a visitor for pleasure, in other words, you're here as a tourist to see family or to go to Disney World or the Grand Canyon, usually they admit people for 6 months. If you're here as a visitor for business, usually the next question you get from the Immigration Service is, well, what exactly is your business? And if you tell them that you're going to a conference, let's say you're going to a medical conference that lasts a week, then frequently they'll only grant you, maybe that week and a couple more weeks. Or if you say that you're here for some kind of temporary project, they want to know how long it's going to last, and they only admit you for that period. If you said that if you told the Immigration Service officer at the airport that you were here to conduct research at some institution as a volunteer, I think they're going to ask you additional questions, and there's a risk that you wouldn't be admitted. Now, people come here with visitors visas to do medical clerkships, and I'm sure a lot of people who are listening to that or have had that experience. But the medical clerkships are are structured and they're for a particular period, and there's specific rules that allow people to come here for medical clerkships. I would be nervous that coming here to do medical research as a volunteer would sound like employment. It would sound open-ended to the officer that you're dealing with.
Someone here says we don't need to rewrite our questions that we posted on Facebook. No, I would like you to guys to write your questions here again. Someone says if one applies for electronic diversity visa lottery and he loses, would that decrease his chances to get a B1 visa?
Well, it might. I mean, the risk would be, as I said, if you're applying for a J1 visa or a visitor's visa, you have to demonstrate non-immigrant intent. And when you apply for that visa lottery, the information, your application is going to the U.S. Department of State. It's the same agency that operates the consulates. I've never heard of that happening. I've never heard of someone being denied a visa, a visitor's visa, or a J1 visa, some kind of visa that required non-immigrant intent, because that person had submitted an application to be in that diversity immigrant visa lottery. It's potentially it could happen. So overall I would say there's some risk there, but it's a small risk.
There is another question. He says, is the paper of need or the letter of need which we should get from Syria is an absolute requirement for J1 visa? Considering the Syrian situation, it's hard to get it. Is there a way to waive this? I think it's mandatory to have the letter of need because everybody is getting it. And I know it's hard, but there are many people that can do that. Is there any way we can waive this paper or this letter of need?
I don't think there is. And I think the rule that you're dealing with there, the people who would make that decision would be the ECFMG, because they're the ones that issue the DS 2019 form that allows you to get a J1 visa. I don't think the ECFMG would issue DS 2019 form unless you had that letter of need from the Syrian government. I just heard you say that the Syrian government is continuing to issue those letters of need, right?
Yeah, exactly. There are actually, I know many friends, they are getting it from Damascus, and it's available for many people. It's I think that they just need to work harder to get it, and you don't need actually to be there personally to get it. You can ask anyone who knows your ministry number أو رقم الوزاري. If someone knows that number, then he can go for you and he can apply for that letter and you can get it. I've done it for my friends, and they are still doing it for many people. Someone else said, go ahead. Sorry.
Well, I think my sense, and you can tell me whether this sounds correct to you, is that whatever else is going on in Syria right now, the Syrian government continues to have the Syrian government and Syria in general gets a lot of benefits by having physicians in Syria go abroad to get medical training and to establish themselves in medical careers outside the U.S. That there are a lot of benefits that flow to Syria from that, and I think the Ministry of Health recognizes that, and I think that they're going to continue to issue those letters. Yeah, even though, as I said, it's in a way it's absurd. The idea. There's just more conflict all the time. The idea that people are going to go back to Syria, it seems that idea seems less and less plausible, really. But the system is still going ahead. They're issuing these letters of need, and people are getting J1 visas.
So far we have finished only 7 questions. We still have actually 35. So someone asked, how do we prove that we are gonna stay temporarily for J1 visa?
Well, that's going to vary sort of person to person. I mean, one way that you would do it, I suppose, is if you had a letter from a hospital where you had a job offer saying, well, we're offering this person a job as a physician back here at the end of his training in the United States. The other ways that you prove intention to go home, and this is true. People who are getting visitors visas, people who are getting student visas, people who are getting J1 visas, they're all required to show non-immigrant intent. And the ways that you show non-immigrant intent are showing that you have family ties, you have family in Syria, so you're more likely to go back there. Your parents and brothers and sisters and the whole family's there. You're going to be going back. You have property there. I mean, the family owns a home somewhere. And we have property here, so I'm going to be coming back. I have a job offer to work as a doctor at some hospital after I complete this training. Those are the type of and I suppose if I mean, I can't really coach somebody what to say, but if they say, well, problems in Syria are getting worse every day, you really expect me to believe that you're going to be coming back? Say, well, I'm going to be coming back because I am Syrian, and I'm going to want to use this training that I'm getting to help my country. Is that so hard to believe? That's so hard to understand that a Syrian person who was born in Syria and had family there is going to want to come back and help the country? Yeah, of course I'm coming back. So,
Yeah, yeah. I think that
okay.
actually they don't ask this question because they know that most of the time that the person will be struggle with the question. It's very hard to answer, especially
Mm-hmm.
if the family of the person is already outside Syria, and
Mm-hmm.
he is already outside Syria. So if he has nobody left in Syria, and he goes to an embassy which is maybe in Lebanon or in Jordan, and he says, "Oh, I want to go back to Syria." Well, you are already left Syria maybe 2 years ago, and your family
Mm-hmm.
the same. So that's why I think that nobody asks that question in any interview,
Mm-hmm.
because it's impossible, especially for the J1. I would say that this is possible for the B1 and B2 visa. If someone applies
Mm-hmm.
for a B1, B2, yeah, definitely they will need a proof that you're coming back to Syria, and they need a really good reason why you're going back. But for J1 and H1, they already know that you're a doctor, and they already know that there is a waiver. There is, I'm sorry, there is the 2 year.
Mm-hmm.
The 2 year policy, so they know that you are obligated. You have to go back
Mm-hmm.
after J1. So that's a good reason for a J1. For H1, the same thing. After your visa is done, then you have to say, after my training is done, I have nothing, I have no intent to stay in the United States, and
Mm-hmm.
then that may help. For the B1, B2, I would say it's actually almost hard to prove that you're going to stay temporarily.
Mm-hmm.
Another question says, can I
Well, let
get?
me let me say
Sure.
one more thing about that. I'm representing a lot of people right now who are applying, who came to the U.S. in J1 status and they're getting waivers. And for people who are getting waivers through the Illinois Conrad 30 program, one of the requirements is that they want a statement from the applicant about why they want to stay in the U.S. And their question is, well, look, when you got J1 status, you signed a DS 2019, you promised that you would go home. Now you're telling us you want to stay. Um, and as I talk to physicians, frequently what I hear, I talk to them about um, about doing a statement to deal with this requirement, they say, in the long run, I do plan on going back. There's more I'd like to do in the U.S. I did this training, and I'd like to work for as an attending for a while and kind of learn more. But in the long run, I do plan on coming back. And just because there are I think a person could say that about Syria. That the um, in spite of the problems that are there right now, um, you still, if a person is Syrian and was born there, that they would have a kind of a long-term goal of coming back and having a career um, and making Syria a better place. So I don't think that's a ridiculous thing for somebody to say.
Yeah, I agree. uh, there's a question that says, can I get J1 visa or H1 visa if I'm already asylum applicant? Can I get dual status like asylum plus J1, asylum plus or asylum plus H1? And do you
Mm-hmm.
think these visa affect my asylum case?
Well, it's difficult to say. I mean, if you apply for asylum, you're saying I can't go home. I can't go back to Syria because I'm afraid, because I think there are people there who will be looking for me, and so I can't go back. It's hard to say that and then say a few minutes later or a day later or a month later um, that you have the intention of returning home. Um, I don't think um, when you apply to the ECFMG for if you go through the process with the ECFMG to get a DS 2019 form, I don't think they ask you if you've ever applied for asylum.
No, I don't think so. They don't.
Um,
Well, I think
so,
that the problem, I think that the intention of this question is someone who came in here and applied for asylum and then
mhm,
is doing interviews, and he will be maybe granted a match or granted a position in a hospital. So after he got accepted, then he want to start working, but he doesn't have the approval, or his asylum has not been accepted yet. So he doesn't want to start working with the status of asylum, because what if he got rejected? Because if he got rejected, then he will be in trouble. So I think that his intention is he want to apply for a J1 or H1 visa after he already applied the asylum, just in case if his asylum got rejected, so he would stay on the J1 or H1 visa and continue with his residency.
well, I think it's sort of one or the other, and I think if you have a pending application for asylum, I don't think you could apply for J1 status without withdrawing the application for asylum.
Mhm. Yeah.
I think it's one or the other.
Because I think when someone applies, maybe yeah, he can get the papers from ECFMG for J1, but when he applies for the J1 visa, either from the States or if he goes outside, then either way he has to tell them that I already applied for asylum, so he has
Hmm.
intention for staying in the States. So he has intention, and they already know that he already applied for asylum. He doesn't need to tell them. They already know. It's going to be really hard to understand his situation, that it's actually the opposite. Yeah.
Yeah, and it would be risky, I think, um, to to go outside the U.S. and apply for a J1 visa, but you wouldn't want to do it while you still had an asylum application pending. Oh, and first of all, if you left the U.S. Um, after applying for asylum, your asylum application would be considered abandoned. If you tell the government, I can't go back to Syria, I'm afraid to go back to Syria, I think I'd be subject to persecution, and then and then you leave the country and go back there, I think legally that acts as you've abandoned your application for asylum. In order to pursue asylum, you have to stay here in the U.S. Plus, I would be really nervous about applying for a J-1 visa outside the U.S. If you've applied for asylum, because they would say, well, if you apply for asylum, it makes it difficult for them to overlook this issue of non-immigrant intent. If there's a record of you saying that that you can't stay in Syria, and plus there's another level of risk, and that is there's some penalties and disadvantages that the person can suffer if the Immigration Service thinks that you've filed a frivolous application for asylum. If you apply for asylum and you tell the Immigration Service that you can't go back because you're afraid to go back, and then you do go back, I think there's a risk there that they might say at some point in the future, well, that application for asylum must have been frivolous because your fear of going back to Syria couldn't have been that bad because you went back there. So I think I think you should, if you're going to pursue something other than, if you've applied for asylum and you're going to pursue something other than asylum, I think you'd want to consider withdrawing the asylum application. H-1B is a little different because H-1B doesn't require non-immigrant intent. And I think you should discuss that issue with the attorney that helped you apply for asylum.
Actually, I received a few requests if it's possible if we can record this presentation and this workshop. Is that okay with you, Dr. Mr.?
Yeah, that's okay.
And is it okay if we upload it on YouTube too?
Sure.
Okay. There is a question says, I have multiple entry B1 visa. If I go to a consulate for J1 visa and they deny it, will they cancel my B1 visa too?
Well, it would depend on why they denied it, I think. If for some reason they believed that you did not have the intention of returning home, in other words, they believed that you had the intention of staying permanently in the United States, they could cancel the visa.
I have actually a personal issue that happened to me, that I had a J1 visa, a valid J1 visa, and during the period that my J1 visa is valid, so I went back to Syria. That was in 2011, and then I went to the consulate and I asked them to get another J1 visa while my J1 visa, the first one, is valid. So what they did, actually, they canceled my current J1 visa and they said, we will give you another one in a couple of weeks. Actually, it took them 3 months. So you got to be careful. So that delayed actually my residency for 3 months for this reason, and that happened to me personally. So you got to be careful if you want to apply for another visa while you have a valid visa already there. Actually, when I applied for my J1 visa, they didn't cancel the B1 that I had before, but as I said, it's still possible. It's yeah.
In a way, it doesn't. There's two points I think that you need to keep in mind. One, that the consular officers, those visa officers at the U.S. consulates, have a lot of authority and a lot of discretion. Nobody's going to overrule them. They can kind of do whatever they want. We immigration lawyers complain about particular decisions, and there's an office in Washington, D.C., a State Department office that sort of oversees the consulates. You can complain to them, but those complaints are usually not very effective. There's a general rule that the decisions made by consular officers looking at applications for visas and consulates outside the U.S., it's very difficult for those decisions to be overruled, and they really have a lot of discretion in terms of using their own judgment about whether someone is eligible or someone has done something to violate some rule.
There is a question. I have Syrian.
One other thing I wanted
Sure.
on the B1 visa, if you still had if you went to apply for a J1, they didn't give it to you, and you still had the B1, and you came back into the U.S. with the B1, you could do that. But if you entered with the B1 or visitor's visa, B1, B2, you wouldn't be able to be in the residency program because you would have entered as a visitor. So it's even if you're able, if they didn't cancel the visa and you re-entered in visitor status, it doesn't help you that much because you're not in the status that you want to be in. That you're not in the status that's going to allow you to participate in the program.
Yeah, actually, some people, what they do if they apply for a J1 and they got rejected or it took too long. So what happens if the program takes the position away from that person, and if they still have a B1 visa, what they can do, actually, they can still use it to come back, maybe do some research, do some electives, clerkships, and then maybe apply for the match again next year. And then they get matched again, and then they can apply for a J1 visa maybe next year with a different program. So maybe they can do that, but of course they will lose 1 year because if they didn't get the J1 visa. Someone asked, I have a Syrian and European citizenships. I was born, lived, and studied medicine in Syria. Do I have to apply for the J1 using the Syrian passport, or can I apply through my European passport?
Well, I think that would depend on who issued the
letter of need.
Yeah, the letter of need. So if you have a French citizenship and a French passport, and the French government will issue the letter of need, then you could get J1 status as a citizen of France, and you would then be subject to a requirement, I think, that you live for 2 years in France in order to comply with the 2-year home country residence requirement. But that's how that decision would be made. It would depend on which government issued the letter of need.
How many times we can leave United States with J1, and should we return back to the embassy to apply for the visa again when we have a vacation outside USA, or we should stay 3 years in a row?
Well, the safest thing once you get here is to stay. Every time you leave and have to apply for a new visa, there's risk that there'll be a delay or there'll be some problem and you won't get the visa. Sometimes people have situations where they just have to go home. But I've met a lot of people here in the U.S. who are from Syria and other places, Egypt, Pakistan. When they get here, especially physicians in residency programs and fellowship programs, they really don't want to leave until they have in their hand a document that allows them to come back to the U.S. So there really isn't any limit. It's just that every time you leave and you have to apply for a visa at the consulate, there's a risk that there'll be some kind of problem.
So another question, actually, I think we answered that question. Is there any chance for TPS to be renewed designated to new Syrians? I think that he's asking about like a new registration for TPS. Is there any chance that this may happen?
I don't think so. I mean, that was unusual that there were two separate registration announcements. For these other countries that I've mentioned, Honduras, El Salvador, they haven't done that. That was the only people. Haiti was also designated for TPS after the earthquake in, I think, 2010, January 2010. There was the original announcement. You had to have been in the United States when that announcement was made. Syria is really the only situation I can think of where the situation got so much worse that over a year later they had another designation.
Another question, is doing extension for B1, B2 visa affect further applying for any other visa in the future?
No, as long as if the risk is if you apply for an extension of visitor status and it's denied, and then you have to leave sort of abruptly, and that you really, there's this period of time, well, let's say that you apply for an extension of visitor status 1 month before your status expires. So you file the application, the next month goes by, you don't have a decision, another month goes by, and then you get a notice from the Immigration Service saying that they've denied it. Then and that you have to leave. There's this question of, well, what was your status for that period of time before you got the decision, after your previous status expired, but before you get the decision saying you had to leave? There's a risk that a consular officer in the future might say, well, there was this period of time when you overstayed your visa. You stayed longer than you were permitted, and your application was denied, so therefore you overstayed. That's the risk. And there's a rule that says if a person ever overstays a non-immigrant visa, like a visitor's visa, that the visa in your passport then becomes invalid, and also in the future the only place you can apply for a visa is in your home country.
I have actually another 40 questions. How much time you have, Mr. Wintersteen, with us?
Well, I could talk for another half hour, let's say.
Okay, so if you want to just we'll go through them very quickly.
Okay.
So one of them
I'll
asked
try to make my answers quick.
No, it's okay. One asked actually if it's is it possible that they will stop the TPS for any reason, or it's going to be stopped being issued anymore? And we say that it's almost didn't happen before. And then his another question: can I apply to anything else, or what's going to happen if it's stopped? And I think that after TPS is stopped, or if he didn't apply anymore, then he's going to go back to his previous non-immigrant status, to whatever visa that he had before, which was, if it was B1, so he's going to go back to B1, J1, he's going to go back to J1. Even if that visa or that status has expired, then he's going to go back to that status, and then he needs to start from the beginning.
Well, and two things. I think that the TPS for Syria is going to continue for a long time. I'm pretty sure of that. I mean, just based on two things: the severity of the problems in Syria, and two, the fact that there's been this pattern in the U.S. in the past. When some places designated for TPS, they keep it for a long period of time. And when they ended TPS for Liberians, they had this sort of transition period where people had a status called deferred enforced departure, which was it was similar to TPS, and it was People were allowed to keep their work authorization. So I think TPS is going to continue for a long time.
Is that possible to apply for H1 or J1 from Canada?
H1, yes. If you have a H1B approval notice, an employer has filed a petition, petition's been approved. You can travel to Canada, apply for an H1B visa at one of the consulates there, and then come back and they'll grant it. Because, and this sort of goes back to the story I was telling before, the difficulty with getting a J1 visa in Canada is Canada will say, the people at the consulate there will say, we don't have any way to judge whether or not you intend to return home, so we really can't make a decision.
What about J1?
If you had a DS 2019 form and you went up to one of the consulates, the U.S. consulates in Canada, I think they would decline to consider your application because they would say we can't make a decision about whether you have the intention of returning home.
So
We
where
can't make it.
they should apply?
Well, in Syria or is the
No,
U.S.
embassy.
consulate in?
No, it's actually closed since July 2011.
Okay, so where do people?
They go actually Jordan, Turkey, Lebanon, but
Mhm,
what if they apply to any other place? Is it possible? I mean, majority they do that in Lebanon, Jordan,
mhm,
Turkey because it's close to Syria, and some people they do it from Egypt too, Saudi
mhm.
Arabia, UAE, but I'm not sure about other places.
I don't think they would let you apply in Canada. Um, I think they would say that they don't have any way of judging your intention of going back, and they would tell you that they can't make a decision.
Another question says applying for H1 or J1 puts you on risk to lose your 6 years B1, B2 visa. I think we already said it's possible when you apply for another visa that the other visa could be canceled.
Mhm. Although,
Uh,
if you're applying to the Immigration Service for a change of status here in the U.S., I mean, they can't cancel. The U.S. Immigration Service can't cancel your visa um, if you're applying for a change of status to H-1B in the U.S.
mhm.
That would only happen uh, if you
But
were outside the U.S. dealing face to face with a consular officer in one of the U.S. consulates.
mhm. And I think that if someone changes his status, then like let's say someone changed from B1 to H1, and
Hmm.
then he wanted to leave the country, then when he applies, he cannot come back on B1. He should apply for an H1 visa. He should not
Right.
use the B1 visa anymore because if he comes
Hmm.
back with a B1, his status completely will be changed again back to
Right.
B1.
Right. If he enters in B1 status, then he's in B1 status, and he's not in H1B status, which means he can't work.
Mhm. Are we eligible for a green card after finishing the J1 waiver, or we have to start all over with H1 visa and national interest program? I think I'm doing this now actually. I'm doing the J1 waiver. After you finish the J1 waiver, like you finish it 3 years and then you apply for green card, then it takes 4 to 6 months. Is that correct?
Yeah. Once you've finished that 3-year obligation to for the J1 waiver, you're immediately eligible for. You've removed the obstacle to becoming a permanent resident, and for people who are doing J1 waiver jobs, what I advise them to do is have the employer file an immigrant petition, file labor certification and immigrant petition while you're still in H-1B status, while you're completing the 3 years. And that way, as soon as you're through with the 3 years, you can apply for adjustment of status and it'll happen pretty quickly. The mistake some people make is that they don't do anything until they've completed the 3 years, and then if you're starting from the very beginning to get to get a green card then, it's going to take another year and a half, 2 years to get your green card. The thing you want to do is there's 3 steps to becoming a permanent resident based on an employer's petition. 1 is labor certification, 2 is the immigrant petition, 3 is the application for adjustment of status. If you're doing a 3-year J-1 waiver job, you're not eligible for adjustment of status, but you could have the employer do those 2 preliminary steps, the first of the 3 steps, so that as soon as you finish the 3 years, then you can apply for adjustment of status, and as you said, you'll get the green card in 4 or 6 months.
So if someone is doing the J waiver job and during that time he got married to an American citizen, and after finishing the 3 years, should he apply through the hospital that he's working with, or he can just apply for adjustment for status through his wife? Or
well, he would really have a choice. You couldn't file the application for adjustment of status based on the spouse's petition until you've completed the 3 years. You're not eligible for adjustment of status for a green card until you complete the 3 years, and it doesn't matter if you're applying for a green card based on marriage to a U.S. citizen or an employer's petition. So I guess what I would recommend, it depends on the employer and what you're dealing with the employer. If the employer will do those preliminary steps during the 3 years, and that as soon as you've completed it, the 3 years, you can apply for adjustment of status. In a way, that's easier than applying based on marriage to a U.S. citizen, because if you apply for permanent residence based on the marriage to a U.S. citizen, you're going to have to do an interview in person with the Immigration Service, with your spouse there, and prove to the Immigration Service that it's a real marriage and not a fake marriage just for immigration purposes. If you're applying for a green card based on an employer's petition and approved labor certification, then most of the time the application is going to be considered by mail, and you're not going to have to go down to the Immigration Service for an in-person interview, and also bring your spouse down there and sit there in an office and be interrogated about your marriage. It's better to avoid that. On the other hand, here's another consideration. Sometimes people finish a job, a 3-year waiver job, and at the end of the 3 years, they want to leave. They don't want to stay there anymore. The only reason that they stayed at that job was to get the waiver. So they don't want to have any kind of obligation to stay with the employer. So they don't want to ask the employer for anything, and they don't want to get a green card based on the employer's petition. If you have the opportunity to immigrate based on a marriage, then you don't. Sometimes it makes sense to do that, because you're not going to end up with any obligation to the employer.
Okay. Someone asked, what exceptions are there for someone who has been in the United States beyond 1 year for an asylum application? I think my understanding is someone who stayed here for more than 1 year, and then he applied after 1 year. And what are the excuses? Because he said, would financial hardship or inability to afford an attorney is a considerable excuse?
Well, it might be. I've seen the situations where immigration judges or immigration service was sort of lenient on that 1-year rule. And one thing that happens all the time is people come here and they don't apply for asylum, and then let's say that you came here to the U.S. And after you'd been here for 8 months, you get a phone call from home, and your parents tell you, there were some really scary guys who came and knocked on the door, and they said they were looking for you, and that as soon as you come back, you better report to them because you're in a lot of trouble. And you think, oh, I know who those people are. No way I'm going back. But at that point, up until then, you really didn't have any reason to believe that you didn't have any reason to fear persecution. but something happened in the home country, and that's when the 1 year period begins. You see what I mean? Or you're in the U.S. And there's a change in government, and the new government is the government that you're afraid of. It's when that change of government happens. It's when you begin to have some reason to fear persecution. That's when your 1 year period begins. That's the general argument.
Someone asked, is the J1 hardship waiver guaranteed if I have American citizen child given the situation in Syria? I think my understanding is this person has a J1 visa and he would like to waive it by hardship or something based on his American citizen child.
Well, I guess I'd say two things about that. One, dealing with the Immigration Service, absolutely nothing is guaranteed. But with the situation in Syria, it's hard to imagine that a well-presented application would fail. I think dealing with a hardship waiver, hardship waivers are one of the things that I think you would always want to have an attorney prepare it. And when you went to see an attorney, the attorney would tell you, we'll do our best, but nothing is guaranteed. But that, with the situation in Syria now, I would say that is as strong a hardship waiver as you're ever going to have. So.
Yeah, there is someone says that he is doing his residency now and he is on TPS. That's his status. So in case that he applied for extension, like within a few months or whenever it happens, he applied for extension, but the extension, it took longer time or it was delayed and his status got expired, or like he passed the time of the TPS expiration date. So what he's going to do during that time?
Well, I mean, the big question is, when you apply for TPS, one of the benefits you apply for is a work authorization card, an EAD, Employment Authorization Document. It's a card the Immigration Service issues that says you're authorized to work in the United States. I guess for everybody in TPS, I would advise them to keep a close eye on the USCIS website, so that as soon as they announce an extension, you can apply, you can file a new application. I think sometimes the Immigration Service makes these announcements that the employment authorization cards for all Syrians who've been granted TPS they're automatically extended. But all you can do is just keep an eye on the website so that you know when you can apply to extend, and apply to extend as soon as you can, as soon as possible.
Someone asked, what are the requirements for an extraordinary ability waiver to be able to apply for a green card? Like how many publications, for example?
Well, extraordinary ability, it's the EB1 category, and you can be granted. You can prove that you're eligible to immigrate to the United States if you file a petition and show that you are a person of extraordinary ability. And there isn't. You need the requirement that the standard is you show that you are at the very top of your profession. I get this question all the time, but usually I don't get the question from people who are born in Syria. I get it from people who are born in India, because for a number of reasons, people born in India are subject to severe backlog. If you're a citizen, if you're born in Syria, you don't need EB1. You don't need to prove extraordinary ability. There's sort of
They can apply for J waiver. It takes only 3 years. EB1, I think it takes 5 years.
Yeah, well, extraordinary ability would not grant you a waiver. Having an EB1 extraordinary ability petition approved would not waive the 2-year foreign residence requirement.
Uh,
It's not a way to get a waiver of the 2-year foreign residence requirement. It's a way to immigrate, but there's easier ways to immigrate.
Someone asked, what about TN visa?
TN visa is TN status is a status that's only available to people who are citizens of Canada. But you can't really do, and it's part of the free trade agreement between the United States and Canada. So the people working in certain professions, and there's a list of professions in the TN regulations, you have to show that you're within one of those professions and that you're coming to work in the U.S. and really all you need is a letter from the employer. But it's useless in terms of for physicians because you can't do medical practice. You can't do patient care. Physicians from Canada, physicians who are citizens of Canada, can only get TPS status to do research or do teaching. So it doesn't really help in terms of someone doing residency or practicing as a physician. People who are citizens of Canada have some advantages in dealing with the J1 2-year foreign residence requirement because you can actually be in the U.S. in H-1B status and still be, if you're a citizen of Canada, and still be subject to the 2-year foreign residence requirement, the J1 2-year home country residence requirement. But so if I mean, I don't know if there are very many people who are citizens of Syria and also citizens of Canada. I've seen it a few times where you had someone who was a citizen of Lebanon. I've had a few clients who are citizens of Lebanon who are also citizens of Canada. But if you were born in Syria but you were a citizen of Canada, it would give you some advantages in terms of dealing with the J1 2-year foreign residence requirement. And you could get TN status, but TN status really wouldn't help you in terms of doing a residency or fellowship because TN physicians can only do teaching and research in the U.S.
Someone asked, I think this person is asking about TPS extension. He says if someone get the receipt when we apply for the extension, he heard that it is enough to continue working until we get the new work permit card. The receipt that he receives when he applies for the extension.
I don't know the answer to that.
I think that the best one to know is someone who applied for extension last year. They can ask that person. I don't know actually personally because I didn't apply for extension yet. I already have a TPS, but they didn't open a new extension yet, so I don't know. I can't tell. But from what I know, that you have to have a current status of TPS.
Yeah, and the problem is dealing with the employer. Employers are not supposed to employ anyone in the United States unless that person has some document that shows that they're authorized to work. If your authorization to work is an employment authorization card that you got through TPS and it expires, you need to have something to show the employer that your employment, your authorization to work has been extended. Now that could be either a new card or if the Immigration Service has made some announcement that all the employment authorization cards for Syrians who are granted TPS are hereby automatically extended for 6 months or something. And they do that sometimes. If you had an announcement like that you could show to the employer, the question is what you could show. What could you show to the employer? Because if the employer doesn't see anything that shows that you're authorized to work, they won't let you continue to work.
Mhm. Yeah. So how much time does the asylum application need to be processed and considered?
Um, well, there's nothing, there's no definite rule on that. If you Well, it depends on the person's status. If you apply for asylum and you're out of status, whatever status you had is expired, then they will make a decision on your application pretty quickly. I think they'll schedule you within 45 days, and you'll have an interview, or you'll have a decision within 2 weeks after the interview. But if you are in status, um, then I think it's sort of up to them. And what I have heard recently, I used to do some asylum applications. I really don't do any asylum work right now. Um, what I've heard is that I've heard people complaining because the asylum office has been very slow uh, in scheduling interviews and making decisions. So it's really up to them, and they're going to take however much time they want to take. The asylum office. There's a particular office within the Immigration Service, the asylum office, that's in charge of making decisions in asylum applications, and it's really up to them.
So someone asked, I have a TPS. Do you recommend to stay on TPS? And I think that this guy is applying for residency. So I'm assuming that
Mhm.
if he got matched and he want to start his residency and he's already on TPS, would you recommend him to continue on his TPS and finish his residency, or to change it to J1?
Um, I guess my recommendation would be if you have an employment authorization document from TPS, my advice would be that you keep that, um, and not go to J1, because if you go to J1, then you're going to be subject to a 2-year foreign residence requirement. If you're working based on an EAD, an employment authorization document that you got through TPS, then you're not subject to the 2-year home country residence requirement, and you're not going to need a waiver.
Yeah, I think that I have a few friends who are doing that. They are already on just TPS and doing residency, and they are fine. And the other thing, just like you said, the TPS could be changed to green card with a few different, with a few specific situations. So it is okay that you can change TPS to green card in specific situations. I think that he want to get the J1 because he want to change the J1 to green card. So, but the TPS you can change it to green card later if you are
Mm-hmm.
on TPS only with specific situations like with work, like an employer who's gonna sponsor you for a green card through the TPS.
Mm-hmm. Yeah, I don't see any advantage in going to J1 status. If you have work authorization through TPS, um, uh,
Someone asked if someone is on J1 or TPS, how can he or she bring parents and siblings to the United States?
short answer is they can't. I mean, um, there's no way that someone in TPS or J1 status can file a petition for parents or siblings. There's no way that a person who is a permanent resident can file a petition for parents. If you have a green card, in order to file an immigrant petition to bring your parents here as permanent residents, you need to be a U.S. citizen. And same thing for filing immigrant petitions for brothers and sisters. So the parents are going to have to, if you want to bring the parents here, they're going to need some other basis for applying. They can apply for visitors visas kind of individually, uh, but there really isn't a system for people who are TPS to bring siblings and parents.
Can someone with a J1 work? Uh, can someone with a J1 work a second job if the second job is willing to sponsor a second visa for me?
No, no, for J1, no. In H-1B you can, in J-1 you can. You can only work for
One
the
employer.
employer, the institution that's um, uh, sponsoring you for J-1 status.
Can a person with TPS travel outside the United States and then come back without any problems?
Um, there are provisions for that. You have to apply for what they call advance parole, for an advance parole document, which is permission to leave and re-enter. Um, and and having temporary protected status makes you eligible for advance parole, but just having TPS status by itself doesn't allow you to leave and re-enter. Having TPS status makes you eligible to apply for advance parole.
Someone says he came with a B1 B2 visa to do a CS exam, the USMLE CS exam. In the airport, the officer he wrote B2 on the passport. Another friend of him he put B1. So is there a reason or why someone had a B1, the other one had a B2?
I don't know. A B1 is visitor for business. B2 is visitor for pleasure. And as I said before, if you're admitted as a B2 visitor for pleasure, usually they give you 6 months. If you're admitted as a B1 visitor for business, they usually only give you the amount of time that you need to accomplish whatever purpose it is. Um, so it sounds like, so if you said you were coming here to take the exam, let's say, well, when's the exam? It's in 3 weeks, so they just give you 1 month. They give you, allow you to stay for, for 4 weeks, for 1 month. It sounds like, I guess I'd like to know if the person who that they wrote B2 in the passport, when the person was admitted in B2 status, if they gave him 6 months. If they did, in a way they're doing you a favor because you're getting 6 months.
Someone asked a long question. He says, I have two stamps right now on my passport, B1 visa and the J1 research visa. The J1 stamp has expired recently, but he renewed his DS 2019 for another year. In this situation, can I go outside the United States and come back with the B1 visa, or I need to apply to a new J1 visa from an American consulate abroad? I think he should apply for a new J1 if you want to work as a J1. If you want to
Right.
continue to work as a J1, if you don't want to work as a J1, you want to just come as a visitor, then you can come back with a B1. But if you want to work in your research, you want to continue with your research, you have to enter through a new J1 visa.
Right. You can't. You can only be admitted in J1 status if you have a valid J1 visa. If the J1 visa that you have is expired, then you can't be admitted in J1 status, and if you're admitted in visitor status, you will be a visitor, and you won't be able to go back to that research position.
So someone says he is doing his fourth year of residency on H-1B visa. If I apply to national waiver, how long does it roughly take to be granted permanent residency or permanent resident status if I complete 5 years of training there? I think that once you apply for the national interest waiver, then once you apply for it, then you have to start counting another 5 years. You cannot count the previous 4 years. Is that
Oh,
correct?
you know you can. I mean,
Oh, you can? Okay.
yeah, the rule that you just sort of summarizes the old rule, and old, I mean before 2007. That was the Immigration Services rule for a lot of years. In 2007, they changed those regulations, and now you can use, if you apply, if you file a national interest waiver petition, you can use time when you were working in an underserved area before you filed, and I do that for people all the time.
Okay.
So you can use that the time when you worked in an underserved area in H-1B status before you filed, that will count toward the 5 years.
Mhm. Um, is J1?
Let me say one more thing about that. And you can file an application for, you can file an immigrant petition, a national interest waiver immigrant petition, and file an application for adjustment of status, an I-485, before you've completed the 5 years. You just have to have a contract or something that shows that you're committed to working a total of 5 years, and they won't give you the green card until you complete the 5 years. But you can file the national interest waiver immigrant petition and an application for adjustment of status before you have completed the 5 years. And that's kind of, that applies to people born in Syria. The only people it doesn't apply to is people born in India or China who are subject to these priority date backlogs.
Someone asked, does the 2-year rule applies on the J1 research visa or status?
It usually it does, and what you need to do is look at the DS 2019 form to see if they've checked the box. It says you're subject to the 2-year foreign residence requirement. If you're subject to, it's sort of a long explanation, but it's for people who are researchers who got a J1 research J1 research visa. Frequently, they're subject to the 2-year foreign residence requirement because of what's called the State Department skills list. In other words, the State Department believes that there is a shortage in the person's home country of people who have this professional training or this experience as researchers. But you can, in those situations, you can get a J1 waiver based on what's called a no objection letter from the from your home government. In other words, if the Department of State says you're subject to the 2-year foreign residence requirement because there's a shortage of medical researchers in Syria, and you get a letter from the Syrian government that says, we have no objection. You say that there's a shortage of researchers here, but we don't care. We have no objection to this person staying in the United States. You can get a waiver based on that. But you can't get a waiver of the 2-year foreign residence requirement if you are a physician and you did graduate medical education in the U.S. In J1 status. The no objection. The no objection route to a waiver is not available to physicians who did graduate medical training in the U.S., but it's available to researchers.
So actually, I skipped many questions because we already answered to many of them, and there's someone asked if it's okay we can get your email so we can contact you through email.
Okay. My email address is CHW, my initials, CHW at charleswintersteen.com. CHW at charleswintersteen. Charles.
I think it's written on the screen. Yeah. So it's CHW at charleswintersteen.com.
Yeah, and my ability to answer, to give long answers to email questions is kind of limited. If you have a quick question, I'll try to answer it. But and the next week, I'm in the middle of doing a lot of waiver applications to the Illinois program, and I'm just not going to have a lot of time in the next couple of weeks. But I'll do my best.
Someone asked, what if I'm asylum applicant and I go out to United States to another country? I think we said you cannot. If you go outside, then your application will be abandoned.
Right.
Someone, H1 visa needs a statement of need. No, you don't need a statement of need for H1 visa. No. I have 2 passports, one Syrian, one European. I'm on B1, B2 visa on the European passport. Applied for J1 research visa on the same passport. Any problem if I apply for the J1 for residency on the Syrian passport?
No, I don't think so. Just you need the statement of need from the, well, two things. You need the statement of need from the Syrian government, and you will be subject to the 2-year. Uh, Syria is the country where you would have to fulfill the 2-year home country residence requirement.
Can we leave the United States on a J1 or H1 status and re-enter on a valid visitor visa? Yes, you can enter with a valid visitor visa, but you're not going to be able to work as a J1 or H1
Right,
status.
right,
Everything will be revoked. Then you have to come back on the status that you would like to be on. Like if you are on a J1 and you go out, then you want to come back and you want to continue as a J1 job, then you need to come in again with a J1 visa, a new one.
right.
You just said earlier that a J1 or H1 visa that's stamped on your passport, you can leave USA and come back without a problem. Yeah, if you have a visa stamp on your passport that is valid and is still current, you can go out and come back. If it has one entry, then you have to make sure that it's one entry or multiple entry. For the J1, most of the time it's one entry. So if you go out and come back, this is one entry and then it's done. Then you cannot use it
Mhm.
again. For the H1, most of the time, I don't think that it's they give you any entry or anything. They just let you in one time and that's it.
Mhm. Yeah, and those rules actually vary from country to country. And I think for people, citizens of Syria, I think the U.S. is, I think the H-1B visas that they issue are usually just the one entry, and they're really strict and difficult. If you have an H-1B petition that's approved for 3 years because you're in a 3-year residency program. Um, Frequently, I've seen, um, physicians were citizens of Syria, had Syrian passports, and when they give them a visa, it was only valid uh, for a single entry and only for a few months. In other words, you had to enter right away with it, and it was only a single entry. So,
Um,
when if you get a visa, look carefully at it and see whether it's multiple entry or single entry and how long it's valid for, because sometimes it's not valid for the sometimes the visa is not valid for the whole period of time that the petition is approved for H-1B.
I think I still have like five more questions. I don't know if you still have time for them
Sure,
or
sure.
someone asked how long might it takes to switch from B1 to H1 while staying in the United States?
Well, normally H-1B petition for a change of status in the U.S. is going to take the Immigration Service 2 or 3 months, but um, for H-1Bs um, you can do premium processing on those. In other words, you pay the Immigration Service an extra fee of $1,225, and they'll make a decision um, in 15 days.
Someone says, is it okay to do clerkships and then go back to Syria and after that go back to the United States for interviews? I think that the best thing to do is it depends if you have a valid B1 visa or not.
Mm-hmm.
If you have a valid visitor visa, it's okay. You can go back, you can go outside the United States, finish whatever you need to finish, then come back for the match season. It's okay as long
Mm-hmm.
as you have a valid visa. If you don't have a valid visa or it's expired already, if you go out, you have to apply to a new one. So the best thing to do is to stay in the state and not to risk it and stay and apply for the match here and maybe apply for extensions or apply for something different like asylum. But definitely applying for another visa, another B1 visa, especially in this time, I think it's so risky.
Right, right.
If a change of status application from B1 to J1 research was denied before the expiration of B1 visa, can I stay till the end of the 6 months or I will lose my visitor visa status too?
No, if you so the situation is a person was admitted in visitor status, admitted for a period of 6 months. Within that 6 months, applied for a change of status to J1 researcher, and it was denied. You're still allowed to stay for the entire 6 months that they granted you when you came in.
Would a change from visa of J1 research to J1 clinical take less time than applying for a new J1 clinical from another status?
Well, short answer to that is I don't know. To apply for a change, you're applying for a change of J1 programs, and that has to be approved. Um, um, it has to be approved by, I think it has to be approved by the Department of State. Um,
Someone
and
asked,
I really don't know the details on that.
yeah.
Sorry.
Actually, I received a few questions, and all of them we have answered before. They are asking me if they will allow us to apply for a new TPS status. We said most likely this is not going to happen.
Right.
Or they were asking, is it possible that it's going to continue to have extensions for the TPS? Yes, most likely the extensions will continue to happen for the TPS, and
Mhm.
uh,
It's not going to help people unless they've
yeah,
already registered for GPS.
yeah,
They
for
already
people
have
who
one.
already have granted TPS, then they can continue to extend it. Most likely, the extension will happen
Hmm.
for another few years. But for someone who doesn't have a TPS, most likely they will not be able to apply to a new TPS. There is just a follow up for the guy who asked about H1 visa. This guy who's doing now a fourth year on H1 visa, and he want to apply for a national waiver. So his question: do I get a green card once I apply for it, or it's going to take time?
It's going to take time. One, you have to complete the 5 years. They're not going to give you a green card until you've completed 5 years of service in an underserved area. And even when you've completed the 5 years, um, sometimes their processing takes can take another 3 months, 6 months.
The last question I have here, he says, is the multiple entry visiting visa for real? Yes, it's for real, but we don't have that luxury for Syrians. Most of the time,
Hmm.
Syrians, they don't get multiple entry. Most of them, they get one entry. I know in my class, only 1 out of 50 got a multiple entry J1 visa. All others, they got one entry for J1 visa. The same thing for the H1 visa. Yes, it's for real.
Hmm.
And if you have multiple entry, yes, you can go out United States and come back anytime. And this is actually the last question. Thank you very much, Mr. Wintersteen. I'm really glad I have you here today, and we really appreciate having you. I want to thank you a lot, and we will be very happy to have you again in next workshops in the future.
Okay, well, I'd like to say one last thing, and that is, everybody's situation is different. And if you have a complicated situation, I think it's a good idea to have an attorney, talk to an attorney about your situation. I mean, sometimes it seems like um, um, an unnecessary expense to pay for a consultation fee and sit down with an attorney, but um, it's everything I've said here. Um, it's hard to respond to these sort of hypothetical questions, and it's there's really no substitute for sitting down with a good experienced attorney who knows these rules well, and can give you some counseling on how to deal with this whole process. Okay.
Thank you very much for
All right.
disclosure, and uh, um, in the future, maybe we're going to have you again. And thank you very much.
Okay. Well, good luck to everybody in the match process.
Thank you.
Bye.
Bye bye.
Thank you.
So here we guys we close today, and thank you very much for your attending, and we will be able to